to start now.
Sure. Why don't we get started with the housekeeping? Are we still expecting a couple more folks?
We are still expecting a few more.
Okay.
Okay. Well, oh, go ahead, Catherine.
Oh, no, I was just going to say hello, Amin. That's all.
Hi, Catherine.
Don't forget.
Oh, actually, I mean, we are not expecting because Erica's not going to be here, and Corey actually emailed us yesterday, and she can't make it.
Okay. All right, then let's go ahead and get started. Do we have quorum? It looks like we have
I
four.
think we should. I think we have quorum.
Yeah. Okay.
I'll just do a quick announcement for the Zoom protocol. So welcome committee members, liaisons, and members of the public to the Legal Services Trust Fund Commission Rules Committee meeting. Thank you for joining us. We are using Zoom with the goal to foster a more inclusive environment and effective meeting. If you would like to comment during the meeting, please type, "I have a comment" or "I have a question" in the chat, and a message will be sent to the host. Alternatively, you can use the raise hand feature. In efforts of transparency for all those joining this public meeting, whether by phone or by Zoom, we request that you refrain from having side conversations on chat about the content of the meeting. Again, the chat feature is utilized simply as a tool for you virtually to indicate that you would like to speak in order to help the chair facilitate the discussion. A friendly reminder that this video conference, that this is a video conference, so please be aware of your surroundings, and that all Legal Services Trust Fund Commission and committee meetings are recorded and posted to the State Bar's website. Okay, thank you.
Okay, thanks, Chris. I think since it looks like we got everybody that we are expecting, why don't we just jump in? I think, should we do roll call?
Sure. Al-Saraf,
Present.
Fightmaster, Luis, you're on mute, but I see you.
Present.
Thank you, Luis. Blakemore,
Present.
Connolly, Friedman, Meeker.
Here.
Judge Seligman. Oh, he's not. We have quorum. I mean, should I do a roll call for the rest of the liaisons and staff?
Yes, please do.
Christine Gonang, Mark Tony, Selena Copeland.
Zach Newman here on behalf. Oh, hi, Selena. I didn't see you there. Sorry.
Oh, hey, Zach. Hi, Selena.
Hi.
Bonnie
Hello there.
Huff. I don't see Bonnie. Erica Carroll is here, and
I
Chris
think
McConnell.
Bonnie just logged in.
Oh, then Bonnie's logged in, and Brady. Okay, great. So I'll turn it back over to you, Amin, for public comments.
Erica Conley just joined also.
Oh, great. Oh, Erica, you're here. I don't know why you're on my tally sheet. You're absent, but okay, great.
Sorry, I'm a couple minutes late. I apologize.
No problem.
No worries. We're just doing some housekeeping. So I think now, and we're going to have a fairly short meeting, as Dwan mentioned. Before we get into some of the agenda items, do we have any public comment?
There's a
There's no
Andy
hand raised.
Grossman. I'll allow him to talk.
Okay, please go ahead.
Hi, I have a public comment in regards to the issue of expungement and infraction. I am speaking on behalf of Bet Sedek, the legal services organization. We're a nonprofit law firm in Los Angeles that provides free comprehensive legal services and representation, volunteer and court-based self-help services, and legal education to over 90,000 people each year. We provide this comment in support of the proposed changes to the IALTA statute that explicitly categorizes expungement and infraction work as civil services, permitting them to be funded by IALTA grants and allowing them to be counted as qualified expenditures for the purposes of determining future IALTA grants. Infractions are a very common issue in our Preventing and Ending Homelessness project, especially among transitional age youth that we work with. We suspect TAE are often less experienced with navigating unhoused life and are easy targets for law enforcement. We would estimate around 20% of TAE come to us for infractions. Over the last 5 years, the number of cases that involved in expungements and infractions increased from an average of 4 per year in 2016 to 2018 to an average of 60 per year in 2019-2020. For a legal professional, expungements and infractions typically can be handled with very little time commitment, particularly as compared to something like an unlawful detainer. The impact on the client, however, can be profound, as an expungement can have a direct impact on their economic and housing stability. For example, a client recently came to BetSEDEX seeking help with expungement and criminal record sealing. Several years before coming to us, the client had had a good paying job working with a contractor supporting FEMA. When the contractor eventually did a background check after the emergency period ended, an expungible misdemeanor came up. Due to the company's policy, they had to let him go. The client didn't even know that a conviction and arrest for more than 10 years prior could affect him that severely. Eventually, due to the job loss, he and his family lost their housing. When the client came to us, we were able to have the misdemeanor expunged and the arrest sealed. He was grateful we had opened new opportunities for him, opportunities that included a new job so he could give his family the stability and safety they used to have. Because of the integral role such work plays in providing our indigent clients comprehensive legal services, we are in support of the proposed changes recognizing expungement and infraction work as civil services that are counted as qualified expenditures toward and funded by IOLTA grants. Thank you.
All right, thank you very much for that comment. And I think, that comment will likely be helpful to us when we jump in. Unfortunately, we're not jumping into that issue today. We originally intended to. But I think, Dewan, I think it's on for next meeting, right?
Or actually, the update today is related to expungement.
Oh, sorry. I guess I was. Anyways, yeah, okay. My mistake. Thank you very much for the comment.
And we have another public comment, from Charlie Gilling from NLS.
Okay.
Kim, would you
Okay. Jarrell Mitchell from NLS. I'm not
Oh.
writing public comment. Thank you.
Would you like to make the public comment?
No, I didn't raise my hand. I don't.
Oh, you didn't raise your hand. Okay, no problem. Sorry about that.
Jarrell Mitchell from NLS has his hand raised. I'll allow him to talk.
Hello, I just heard you. My apologies. I'm just coming in from another meeting. But is this the opportunity for public comment on the proposed treatment of expungement, infraction, and other related work? Or will that be for the later portion of the meeting?
You can make it now, Gerald, if you don't mind.
Okay. So I just wanted to speak briefly. My name is Jarrell Mitchell, and I'm a senior attorney at Neighborhood Legal Services of Los Angeles County. I represent low-income persons with criminal records, with clearing their criminal records and resolving employment, occupational licensing, housing, and other legal barriers they face because of these criminal records. Neighborhood Legal Services is a nonprofit law firm here in Los Angeles County that provides free legal services to low-income folks. And as part of those services, we maintain a robust reentry and homeless prevention program where we assist folks with criminal records with direct legal services. We also operate expungement clinics, traffic workshops, and other community education events to serve this community, and then engage in policy advocacy at the local, state, and federal levels to address the systemic issues faced by persons with criminal records to help ensure that they have a fair chance to successfully reenter their communities. It is through this work that we have learned how important, how vital it is to people living in poverty to be able to clear their criminal records, because oftentimes clearing a criminal record or resolving a traffic ticket or old traffic debt is essential to be able to help that person achieve housing stability, get a job, reunite with their families, and basically escape poverty. So it's for this reason that NLSLA strongly believes that the expungement, infraction, and related work is of a civil nature and advances the mission and goals of the IOLTA and EAF statute. The proposed recommendation to prohibit IOLTA and EAF funding for this assistance with these legal needs will, for these reasons, negatively impact low-income Californians, especially those with criminal records. As it relates to expungement and infraction work being essentially work of a civil nature, I would just like to highlight that expungement and related criminal record clearing proceedings are not proceedings to determine an accused person's guilt or innocence like traditional criminal proceedings. Often the goal of this relief is to reduce or mitigate the consequences of a criminal record and help persons who have been brought within our criminal justice system to rehabilitate themselves. Relatedly, traffic infraction proceedings are largely administrative in nature and often occur in specialized courts. They usually only carry a sentence of a fine, and like expungement and other criminal record clearing proceedings, there is no right to counsel in these proceedings and sometimes not even a hearing. Both types of proceedings have often been long viewed as civil in nature by the American Bar Association and the Legal Services Corporation. Additionally, these expungement, infraction, and other criminal record clearing work improves the quality of existing free legal services to low-income persons and more effectively serves their needs. In California, about 1 in 3, or about 8 million Californians have a criminal record, have a conviction record, and many more have other types of criminal records like arrests or juvenile records. Having a criminal record can make it difficult, as I said earlier, to find a job, housing, or to escape poverty. And unresolved infraction citations and citation debt can lead to a driver's license suspension, additional arrests, or make it difficult for people to meet their other financial needs. Our services in assisting people with expunging their convictions, clearing their criminal records, and clearing their old traffic tickets have helped our clients find jobs, secure housing benefits, and restore their driver's licenses, as well as get professional licenses. For example, I recently assisted a client who was able to transition from surviving off public benefits to a full-time salary position after we assisted her with clearing her criminal records, which allowed her to pass the necessary background check process for that position. Additionally, I recently also assisted a domestic violence survivor client who had disabilities, who had lost her driver's license and was denied federally subsidized housing benefits because of her convictions and traffic debt. Through our advocacy, we were able to help her clear her old traffic ticket debt, restore her driver's license, get off probation, expunge her convictions, and reverse her housing benefits. Finally, we recently also assisted a client who was able to achieve his career goals and become a part of the real estate field and obtain a real estate salesperson license after we were able to help him successfully expunge his conviction. The point is clear. Expungement, criminal record clearing assistance, and assistance with clearing infraction tickets and debt open up opportunities for low-income individuals and help people to achieve security. So once again, it is for this reason that the NLS opposes, the proposed recommendation of the commission to exclude this work from the IOTA and EAF statute as it's currently written into the statute. This being said, we do also applaud the efforts of the State Bar and others to amend the IOTA and EAF statute to make clear that these funds may be used to assist low-income litigants with expungement and infraction matters. This being said, we would suggest that the State Bar and others broaden the definition of civil legal services to include criminal record clearing relief other than expungement, because other forms of criminal record clearing relief, like arrest sealing, juvenile record sealing, human trafficking vacators, for example, may be necessary to assist clients to remove the barriers they face. And like expungement, these forms of relief are civil in nature. The current proposed definition gives the impression that IOTA and EAF funds could not be used for this similar relief. Additionally, we would suggest clarifying the term criminal proceedings to define this as a term meaning that this is a proceeding that involves the determination of guilt or innocence, where the person faces a punishment of jail, prison, or probation, and does not include expungement and other criminal record clearing proceedings or criminal proceedings involving an infraction where the maximum sentence is a fine or fee or other non-incarceration or probation sentence. Thank you for your time. And once again, NLS strongly believes that the committee should not adopt the proposed recommendation regarding the treatment of expungement, infraction, and similar work, as this work is of a civil nature and doing so will negatively impact low-income Californians.
Thank you, Gerald. Amin, Justice Murray has his hand raised.
Okay, please go ahead, Justice. Justice Murray, I think you're still muted. There you go.
Okay, can you hear me now?
Yes.
Thank you. Can I ask Gerald a couple of questions? Is that appropriate? All right.
I think so. Duan, is that?
Yes, that's fine, Justice Murray.
Yeah.
Gerald, I have a question about the scope of the infraction work that you do or that you're suggesting should be included. Does that include the defense of the charge of the infraction in a court trial? Or are you just talking about, are you just limiting the services to relief from fines or fine reduction post-conviction?
The vast majority of our work involves traffic. In that space is involving traffic citation. So most of our work is focused on helping to that latter part that you described, where we're focused on helping people to alleviate the debt and also educating people about their options. That being said, we have had, in limited circumstances, also assisted people in traffic proceedings where, say, for example, there is no risk of incarceration and where the maximum penalty would be just a fine or fee.
So are you suggesting that that assistance should also be included?
Yes, because in those types of very narrow situations where we're talking about a situation where an individual is not facing any type of either incarceration penalty or perhaps a situation where they may face probation. We're talking about strictly a limited situation in traffic where that person is essentially going to only face a fine, basically a fine or fee. That's largely an administrative proceeding, and it has been viewed as such by other parts of the legal industry.
Okay, and then you also mentioned other forms of record clearing relief. I think you mentioned, for example, human trafficking vacator, and there were a couple other things. I think you mentioned juvenile sealing proceedings, criminal sealing proceedings. Would you consider something like Proposition 47 or Proposition 36 relief to also fall into that same category of other record clearing relief other than expungements?
Absolutely. In the same sense as expungements, Prop 47 relief, as well as Prop 64 relief, a related form of relief dealing with cannabis-related convictions, as well as other statutory reductions under Penal Code Section 17, would also fall squarely within that very similar relief, simply because it's also designed to be rehabilitative in nature. It doesn't go to, and in helping folks to basically prepare and file those types of petitions doesn't question the validity of the sentence for any procedural reasons. These are largely statutes that came about later on after the conviction likely came into play, that allows that person to basically mitigate the effects of that conviction based on after changes in the law.
Well, okay, except PC 17 relief, that wouldn't necessarily relate to a later change in the law.
Yes, my apologies. 17B has existed for a very long time, but
yeah.
Other reductions, it also has, and expungements for that matter, it serves largely a rehabilitative purpose. So in my experience in court, it's often granted after a court has seen a defendant show a certain level of rehabilitation after the conviction has come into play.
Okay, thank you, Gerald, appreciate it.
Okay, thank you, Justice Murray. Thank you, Jarrell. Do we have any other public comment?
I don't see any other public comments, Amin, and I just want to acknowledge that Judge Seligman is now on the line, and Justice Murray is not on the Rules Committee, but he is on part of the working group for the expungement, so we invited him to participate in the committee meeting.
Terrific. Thank you for joining, Justice Murray. And hi, Judge Seligman. So I think let's jump into the consent item first, which is the minutes from the last meeting. Does anybody have any comments, changes, thoughts on those? Okay, hearing none, do we have a motion to approve?
Catherine moves.
I'll second.
Great.
Actually, I can't vote, or can I vote on this?
Oh, can Judge Seligman second, Brady?
On the rules?
On the, for the, you're non-voting, so I don't know if you can second a motion.
No, maybe someone else should do it.
I can second.
Okay, great. Thank you, Erica. Amin, I'll do roll call.
Okay, thank you.
Asaraf,
Yes.
Fightmaster,
Abstain.
abstain. Okay.
I wasn't there.
Blakemore,
Yes.
Connolly,
Yes.
Friedman, Meeker, Jim, are you there?
Yes.
Okay. Yes, you're here, or yes? For
Both.
Okay,
Yes and
great.
yes.
Thank you. Motion passes. Amin.
Okay, terrific. And then Dewan, do you want to jump into the next item? Is that?
Yes. So Erica has prepared a short PowerPoint to update you all on the work of the committee, the working group.
Okay.
Thanks. Sorry, I don't have my my video on. I'm having some bandwidth issues today, so I'm just going to pull up the PowerPoint. Just to provide the committee with an update on the treatment of expungement, infractions, and similar legal services, the members of this working group are Justice Murray, Judge Seligman, and Catherine. So please feel free to jump in during this as well if any of you would like to add or update anything. But a lot of this will be fairly familiar as this topic was recently addressed by the commission. So I just want to provide a little bit of background to make sure that we're on the same page to understand sort of where we arrived with the recommendation. As you all know, that the question of the characterization of expungement and infractions arose during the 2021 partnership grants process, where there was a question about whether this work would be considered civil legal services or criminal legal services, and if it were criminal, whether the partnership grants should be funding projects providing those services. So historically, expungements and infractions are work that's considered qualifying under ILTA and EAF. It has been included in the primary purpose determination and grant awards for qualified legal services projects. So as you know, work that's performed, legal services provided without charge to indigent persons are what goes into the calculation for primary purpose. And so organizations that 75% or more of their expenditures in a given year are devoted to those services would be presumed eligible for an ILTA or EAF grant. If their percentage is lower than 75%, that requires review by the commission. And so when this work was considered qualifying, that would add to or help the percentage for those organizations providing those services. If it were not considered qualifying, it may lower their percentage in terms of qualifying expenditures and may also impact their grant award in the case of qualified legal services projects. The other way it impacts applicants is related to the use of ILTA and EAF funds. So historically, our grant recipients have been allowed to use ILTA and EAF to provide expungement and infraction services to their clients. starting with the 2021 IELTA EAF application cycle, when this question came up through the partnership process, we were underway with review of 2021 grants. So given that this was an open question that required more research, the instruction provided at that time was that applicants could include expungement and infractions as part of their qualified expenditures, but were prohibited or instructed not to use those funds that they received in 2021 to provide expungement or infraction services. So organizations could continue to do that work. They would just need to use another funding source in order to provide those services. So with that question still unresolved, when we reached the 2022 application process, more research was conducted and yielded the conclusion that expungement and infractions are more properly characterized as criminal legal services rather than civil. But in the course of that research, staff also, realized that the statute doesn't actually impose a limitation on including these services, even though they are more properly characterized as criminal legal services. The IELTA statute doesn't contain any sort of qualifier as to civil or criminal distinction. It just says that primary purpose for a QLSP would be an organization that has as its primary purpose providing legal services without charge to indigent persons. But what was clear from the research, consistent with the instructions provided for the last grant cycle, is that there is a prohibition on using IELTA and EAF with respect to any criminal proceeding. So given the results of that research, staff informed the commission at its meeting in June last month of this interpretation, and that consistent with the instructions for 2021 that staff would follow the same plan or maintain the same approach to allow organizations to include this work for qualified expenditures, but not use the funding they may receive through IELTA and EAF to support that work. So then the working group formed in order to address this topic moving forward, in order to determine whether there needed to be any sort of clarification or change to the rules of the state bars or the eligibility, state bar rules, excuse me, or the eligibility guidelines to clarify the treatment and ensure that there's consistent application in future grant cycles. And so one example was that the eligibility guidelines did include a specifier that qualified expenditures were related to the provision of civil legal services. But, as I said, that's not in the statute, and the statute is controlling. So there was discussion about how to reconcile the rules and the eligibility guidelines to conform to the statutory requirements. And during the course of that discussion, the working group focused a bit on the purpose of the IELTA statute, which is to expand the availability and improve the quality of civil legal services to the indigent, while also recognizing that although expungement and infractions are characterized as criminal legal services, that they are often provided in conjunction with civil legal services because of the fact that they can enhance civil legal outcomes and have meaningful impact in areas like housing and employment. And, as Mr. Mitchell, I think, alluded to in several examples that he gave. So the discussion sort of centered a lot on, while the purpose of the IELTA statute is civil legal services, and the belief that the omission of the word civil in the primary purpose part of the statute was probably more of an oversight rather than an intentional omission. Also wanting to include things like expungement and infractions, which are characterized as criminal. So ultimately, the recommendation that came out of that discussion was to look into the possibility of a statutory change to clarify the intent of the statute for civil legal services, while also making sure that expungement and infractions are not being excluded. So an example that I have here on the screen is the 6213A, which is the primary purpose section for QLSPs. So it would add that language, the primary purpose and function of providing civil legal services without charge. But it would also require other updates to the statute to indicate that in this context, expungement and infractions would be considered civil legal services, as well as having an exception to the prohibition on using these funds in criminal proceedings, to allow the funds to be used towards, to allow IL-10 EAF funds to be used towards these services, which is a change from this grant cycle because of the current statutory language prohibiting the use of IL-10 EAF. So the proposed changes would essentially allow the inclusion of expungement and infractions in the future for qualified expenditures, as well as go back to the historical practice, essentially, of allowing IL-10 EAF funds to support this work. So when that recommendation sort of formed, there was recognition that there's sort of a quick timeline regarding this legislative session in terms of making a change that would impact the next grant cycle. And so my understanding is that Dwan and Selena have some more information, I guess, about the next steps related to that.
Yeah, so we circulated the, Donna and Brady both had suggestions on what the legislation could look like, and we shared it with Selena, who I believe is, had reached out to programs to see if there was consensus, because the state bar's position is that we would support a statutory change as long as there's consensus amongst the community. So Selena, do you have an update?
Yeah, and sorry, I was making my lunch since I did not get a full break between the last two meetings. Yeah, I reached out to programs. We have, many of you may know with LAC, we have something called the Directors of Litigation and Advocacy list. So it includes some executive directors, but largely it's the directors of litigation or the directors of advocacy or the senior managing attorneys at legal aid organizations. And this is a listserv that we use to kind of get a lot of substantive discussion and feedback, because we know executive directors don't always see all their emails. So I reached out to our director of litigation and advocacy listserv, and all of the feedback that I got from that listserv was that they were, programs were in full support of the change. Everyone said great work, and they support what I now think of as really a really smart solution that Brady has proposed with this change language, and LAC is also in support.
Selena, I have a follow-up question, if you don't mind. That listserv, is it all programs that there's a director of litigation at every program?
It's not 100%, but it's all the organizations that are heavily involved in our work. I also will email executive directors when there's something larger, like an advocacy update or a funding update. I did not email executive directors this time around, giving the short timeline, but I did hear back from many programs. I haven't looked at the numbers in a while, but I think roughly 85 to 90% of IELTS programs are on the DOLA listserv.
Okay. So would it be accurate that could we, I guess, accurately say that there's consensus? I guess that's the main thing that the state bar staff would need to know.
I think so. And I think I can also share that with legislative staff, that there was strong support in favor of this change.
And so, Selena, do you know then, Donna Hershowitz at the state bar, I know she's been in contact with the legislature as well. Selena, you guys might be on the same email. Do you know what the next steps are? If you could maybe walk through the committee members.
Legislature is out of session right now. They return in mid-August. The language needs to be to ledge staff before they return so it can get amended into the bill. I think it's going to be, I think, Selena, it's going to be part of the bar dues bill.
That's
right?
what I couldn't recall if it was going to go in the bar dues bill in 211 or in SB 498. I think because of where it is, the bar dues bill makes more sense. And Leora, who's the main
anyway, one or the other, but I know the bar dues bill is up on the assembly floor, so the amendments have to be heard on the assembly floor. There's no more committees, which is fine. And then it will have to go back to the Senate, and there's roughly a month or a little bit longer for the legislature to do all of these things. So that's how I understand the process.
And I would also say that if this committee is in support in whatever way we need to communicate with legislative staff, I think by the end of the day, today is best, because I know that several legislative staff are on vacation, and the staffer who we've been working with on this issue, I believe, goes on vacation on Monday.
So it'd just be good to get the language to them if it can today. I agree with that. mean, there's still a little time when the legislature comes back, but it's going to move fast. We are not going to be waiting around for an answer on this.
And then the proposed language, if I understood the public comments earlier today, I believe there might be a suggestion to broaden that, if I heard that correctly from or no, maybe I didn't. I thought that's what either Charlie or maybe Brady.
I thought there was a discussion about what constitutes infraction work that language just says infractions. I think it doesn't specify that. So
what I was actually more concerned with, and I was the comment that expungement doesn't necessarily include all record clearance work. So perhaps a change could be both times that the statutory change refers to expungement, say expungement and other record clearance work, because I unlike the practitioner who spoke, didn't have the understanding that expungement doesn't cover certain arrest clearances, but it would seem to me that for all the same reasons that we want to include expungement, we might include other record clearance work.
Justice Murray?
Yeah, we probably should spend a little more time talking about that expansion, because you know, I get something like record sealing proceedings that should be included. Maybe human traffic victim vacators, but Proposition 46, 36, 64, all of those propositions provided some form of relief from a prior conviction. Proposition 47 reduced certain felonies to misdemeanors. 36 eliminated certain felonies from the definition of a strike for purposes of the 3 strikes law. Prop 64 eliminated certain marijuana possession convictions, but they all include a provision for an exception for a person who would pose an unreasonable risk to public safety. This really, to me, those kinds of record clearing relief procedures are really criminal in nature. I think Penal Code Section 17 was also mentioned as one that you would sort of lump into this other category, and that's a long-standing statute allowing a court to reduce wobbler felonies. That's a certain type of felony from a felony to a misdemeanor, which includes in the interest of justice analysis. I don't know. We didn't really talk about these things. I'm not sure Brady has considered the implications of those kinds of records clearing relief mechanisms. And then the other thing is infractions. I mean, if everybody's fine with the idea that that includes defending against the infraction in the sense of a court trial to prove whether or not the person's convicted of an infraction or not, I think that's fine, but I don't think that was clear to, unless I missed something, I don't think that was clear to the working group that that was what was included in infractions. We were thinking more along the lines of post-conviction relief related to reduction or elimination of the fine. That's my recollection. So I just want to throw those things out for your consideration. Believe me, I'm all in favor of helping people clear their records, because I know the long-term ramifications of these things for individuals in terms of the ability to move forward with their lives, or prevention of the ability to move forward with their lives. But I do think there's, you know, just to say other forms of record clearing relief or something like that, catch-all phrase like that, I think that I open the door to a lot more things than was actually contemplated.
I'm wondering, Justice Murray, if there might be some language which would be consistent with your concerns, which I share, where we could say is expungement, record sealing, and similar procedures that do not turn on culpability, or whatever the language that would deal with your concerns of some of those propositions, which I would agree are outside the scope. I'm also uncomfortable with the idea of infraction defense being included as opposed to clearing fines later, because that is my understanding in traffic court. Actually, it is a criminal proceeding. You have a right to be there. In fact, in our court, our traffic court, unlike everywhere else where we're all remote, people actually appear in the infraction cases because, like criminal cases, there's considered to be a right of confrontation, and they are hearings where guilt is determined. So I think that puts legal services in a place that traditionally I don't think they have been. I don't have a problem with, the definition of for purposes of qualified expenditures. That's a separate question. When I don't have any problem about that, but I would be somewhat concerned if legal services grant money is spent on what essentially would be a criminal defense.
Yeah, I mean, if you wanted to limit the infraction relief, the scope of funding for infractions, you could say something like post-conviction infraction relief or something like that, just as opposed to just infractions generally. But some of these other mechanisms in the law that exist now, or that may or likely to exist in the future, they might be beyond the scope, I think, of what we were thinking could be argued with a straight face to be civil in nature.
And I know that from my recollection too, that was an outstanding issue from the working group meeting, and Erica Carroll in our office did reach out to a couple programs to get more clarity. Erica, could you shed light on your conversations with, was it East Bay Community Law Center in Silicon Valley?
Yeah, so I was able to get some follow-up information from East Bay Community Law Center, McGeorge School of Law, and Law Foundation of Silicon Valley. The work that they perform is very much in line with what you're describing, Justice Murray. A lot of it is the post-conviction infraction work. Essentially what EBCLC said was that they do occasionally represent individuals in court, but it would need to be a compelling circumstance. Like it may be somebody with a disability or somebody who is otherwise very vulnerable that, having the fine imposed in the first place would be very difficult to undo later or to mitigate later. So they said that is a small fraction of their work, but that is not how they would typically conceive of the work that they're doing. It is usually sort of a post-conviction proceeding. So it's not to say that it doesn't happen at all, but it's a small percentage of the work that's being done, as far as I understand. I only had a chance to speak with a few organizations, but so that may be anecdotal, but they were consistent in what they said. So hopefully that's representative of the other organizations as well.
So Brady, if we added language to what Justice Murray is suggesting, that do you think that's an easy change, right,
Yeah.
Brady?
I think that both Justice Murray and
Judge Seligman,
right.
his suggestion about record sealing proceedings, I think that's a great suggestion to add that.
Sorry, Judge Seligman, my boss always asks after you and refers to you by your first name, and that's what popped into my head. But I think that both of those clarifications, post-conviction infraction and expungements and similar record clearing proceedings that don't.
So something like expungements, record sealing proceedings, and post-conviction infraction proceedings. I think that kind of language would cover everything that has been discussed thus far.
And it's consistent, I think, with our intent all along,
Okay.
if I can speak for the group.
I think that's right.
So if everybody's in agreement, then Brady, maybe may I ask you to make that change, and then we can send over to Selena so she has the latest version in hand.
I was just asking if Erica got down the actual language. I'm unfortunately not at a computer at the moment.
And as soon as that is sent to me, I'll get it out to Dola, and I'll also make sure to reach out to all executive directors, and also we had a few like Zoom calls to discuss the issue, and I'll make sure I send it separately to those participants as well.
Okay. Great. And what I can do is, you know, the commission is meeting in 2 weeks, so I'll actually add it to the commission agenda, and then we can just provide everybody an update. We'll probably have something substantive to report back by then.
Given the timeline, does it make sense to move forward between now and the commission, even if this is a draft recommendation? I'm concerned about if legislative staff need it in their hands before August 16th.
Yeah, well, I guess what I was imagining, even though this might not feel completely comfortable, is not moving back to the commission to ask, but having you move forward. If we're in agreement here with the rules committee, I know it's a little bit out of process. It's just we're running into a timing issue with how quickly this change needs to be made. Amin and I don't know other members of the committee, how comfortable you feel with that.
It's Catherine. I'm fine with that. I mean, I guess I want to hear from Selena that she's comfortable with sort of where the discussion landed.
I think I am. I think I want to talk with programs a little bit to see, you know, as Erica shared, some organizations do a little bit of work that wouldn't be covered, and just to find out what the scope of that is. And I haven't done expungement work myself in more than a decade, but I do recall some organizations have done some, and this may have also been nearly a decade ago, some work in specialty courts around representing people who had anti-camping infractions and other kind of work that they thought of as their core work supporting people who are unhoused. So I'd want to figure out a little bit, like, is that something that's big? But at least I can say that this expansion is large, and I think that most programs would very much support this. And if there's a tiny piece that wouldn't be covered, I think that I would not want that to slow this process down. This is huge, and this is a great change.
I guess that's my belief, which is this is a big piece of progress, and given the timelines, it may not cover everything, but it's more important to have the opportunity to get this done. And if it ever needs to be revisited, it could be revisited, but not to lose the opportunity. And it's, from what I understand, legislative staff is interested and willing to make the change and understands the importance of it. And so while we have that kind of support, and staff is really reflecting, I think, the view of their members that we should proceed, and then kind of, if there's something that needs to be fixed down the road because there was a big issue that we couldn't contemplate within the available time, we contemplate it later. But go ahead with something that I view as really significant and important to the clients that we serve. So that's why I think we should proceed.
Dwan and I mean, for the minutes, I've captured that the conversation is about adding clarifying language, perhaps limiting it to post-conviction relief for fractions. But it sounded to me that there was a specific recommendation for additional language that Justice Murray might have listed a few things to make sure that Erica and Brady have the most specific recommendation possible. Would Justice Murray mind repeating for me the sort of sample language you offered? And I'll make sure that it gets to Brady and Erica.
Yeah, so I think we decided on 3 things that would be included: expungements, record sealing proceedings, and then that would cover a couple of different types of record sealing proceedings, and post-conviction infraction relief proceedings.
Thank you very much. Okay, I captured that for them.
And if I can just make a modification to what I just suggested, would it be, Selena, can you give us one day? Because let me and Erica and Brady look at it, and then I would like to float it to the entire committee with asking the working group Justice Murray, Judge Selman, and Catherine to look at it a little bit closer before we send it to you. A couple pairs of eyes, just because the statutory change would make me feel a lot more comfortable.
Of course.
And then we'll send it to you. Okay.
Of course. And I also,
Leah, can you just check with the legislative staff person and just sort of let them know what I know they're gone, but they'll be back, I think, before the legislature gets in session, and just like any timing things that people need to be aware of in terms of getting it to them in a timely fashion so that it can be included.
I will, and I will express that we are very close to consensus and working on the detailed language and find out.
That'd be fabulous. Thank you.
I'll put that back.
Do we need to, I'm sorry, I'm going to have to leave soon because I'm facilitating a meeting at 1. Is there a vote that we need to take, or we're not? I might have missed that part.
We weren't planning on a vote because it's a little bit out of process. I guess my thought was to see if there's a sense of consensus amongst this so we can move things forward. I mean, if that feels comfortable to you.
Yeah, it's fine with me.
So
just didn't want to mess up the process by leaving.
And then when we report out to the commission, then we can obviously be completely transparent that it's out of process. And so this is kind of what happened.
Can I just, I know Erica has a comment, so I'll let Erica go first, and then I have a question on process.
Great, thank you. So I'm far less familiar with all of this, and I think the proposal sounds great. I think it sounds like a really big step. I'm all for moving forward. I will say I do think I would like to revisit at some point this infractions defense issue, just because I hear how it sounds like it's sort of a criminal case, but also it sounded like there maybe isn't a right to counsel, and it might be kind of quasi-administrative. So I don't think we should stop the movement forward, to deal with that. But I did want to kind of revisit it just because I don't know that much and would love to get a little bit more information on how that might be affecting people and whether it's something we should consider expanding to as well, and what the policy issues might be. So I'm just raising that. Yeah.
And I recall discussion in the past, and I didn't pay this much attention to it because it's infractions and really kind of outside what I do now, but I recall there being discussion about statutorily classifying infractions as a civil matter or administrative matter, something similar to what they did with parking tickets, so that there was no criminal overtones to it, and that would be a matter of statute. I don't know if there's where that discussion went. I can't even remember how long ago it was or if it's even continuing, but that might be something to investigate.
Yeah, I mean, there might be other reasons not to expand or to support expanding it to infraction defense, but I just wanted to make sure we sort of had that discussion.
No, I agree. I just wanted to point out there's been discussion to decriminalize infractions before.
Yeah. No, because I do think it's a big issue for people.
Erica, this statutory change is obviously happening out of process, but we are going to reconvene the working group of this committee of this topic to flesh out some guidelines related. So there'll be another opportunity, and then we'll have the full analysis in the memo that we'll send out if there are some things that we need to tie up.
Yeah, no, absolutely. I just wanted to flag it as something that as I was listening, I was like, oh yeah, let's make sure we have that as that further discussion at some point. Thank you. Absolutely. And thank you to the working group. This has been really, really I think a really big step, and I really think it's valuable. So thank you guys.
Yeah, I'll second that as well. I appreciate the thought you guys have put into this and how quickly this is moving. I will say I am sort of a little bit uncomfortable with how quickly this is moving and how little discussion we're collectively. I know that there's been other discussion, but
like if you get the vaccine too quick, it doesn't work, or there's something wrong with it. Is that the same thought process?
Yeah, I think it's something along those lines. But I totally agree. This is a great step forward. And so my question really is on the process level, and maybe this is a question that doesn't have an answer, but is there any loss of momentum, loss of support, or goodwill, political goodwill or whatever it is by moving forward on this now and then maybe later having something else to add to it versus, and I don't know if there is even an alternative to wait any longer to have a broader discussion, because I can envision a lot of folks wanting to weigh in or having a further discussion.
Yeah.
We're kind of captive to the legislative timetable is the problem. And if we don't jump on it at this round, we lose perhaps a year. And that's really the driving force.
And you lose the momentum of what
Right.
is led up to right now. Who knows where we will be next year in terms of availability of funding or whatever. So, it's kind of we're weighing the pros and cons. If it's not now, if we don't do this now, we wait till next year, who knows what the situation is going to be.
Yeah.
Might not get any of what is being discussed now. I don't know. Probably it's hard to say.
That makes sense to me, and I think given that, I would support moving this forward in this way. But it's fast.
I think the more that you work with the legislature, the more you get comfortable with that.
Yeah.
Sometimes there's copy and paste errors, and hopefully they can be later.
My head is still spinning from some criminal justice reform legislation that got passed in like a month last year. So I feel a lot more comfortable about this than I did those things. So anyway.
So it sounds like we don't need to take a vote. Working group will take this back and look at this one more time, and then Duane, you'll circulate it to the committee.
Yeah, I'm going to send out, give me Erica and Brady a couple hours and we'll send it out to the full committee, the rules committee. But Justice Murray, Justice Selman, and Catherine, if you guys could, the three of you could take a closer look, because you're in the weeds with it, that I would appreciate that. And then I'll send it over to Lena. Okay.
Great. Thank you guys. Thank you for the work on this, and thank you to those who, if they're still on, who provided public comment. I think that was helpful in this discussion. I think that was it, right, Duane, in terms of our agenda.
That's it.
Can I ask one more question just as far as process? So I know there's a statutory stuff, but then there's also some like guidance for like qualified expenditures versus what they can spend that we don't need to like do anything with.
The statute cleans it up. There's a proposed change that it makes it super clear, both issues, that they can count as qualified expenditures and they can spend our money on it. So it cleans up both issues.
Sorry, I guess maybe I didn't ask my question very clearly. The legislature, if they get it passed, will that affect sort of the 2022 like funding? Like we don't need to do any sort of other interpretation of the statutes if the legislation passes. Yeah, sorry if you said that and I'm confused. I apologize.
No, you don't need to, because and also depending on if it goes in SB 211 or 498, because 498 is what raises the income threshold from 125 to 200%. For that one, Brady and I already mocked up language in terms of effective date and when it would go, and so we're all clear on that. So if it gets rolled into that's the easiest. If it's for 211, then I think Selena, Brady, and I will need to work on the effective language piece. That's trickier, I think, Selena.
Yeah. The only problem with if it goes into SB 498, we had articulated for SB 498 purposes that it would not apply to 2021 clients because that felt unfair. So that would be a wrinkle, but I think we could work on that.
Yeah.
Okay. I just wanted to make sure because I saw the interpretation stuff one that we didn't need to deal with that at all.
And then in terms of process also for like the state bar rules, like I've been told that once if there's a statutory change, we can do it effective the statute because that's the controlling authority. And then we'll do cleanup on the rules committee and on the either state bar rules or the trust fund commission guidelines. That'll come.
Thank you.
Okay. Do we have any other comments? Any other points of discussion? Okay, I think with that, we are adjourned. Thank you, everybody, and have a great weekend.
Great. Thank you.
Thank you, everybody.
Thank you. Happy Friday.